Good afternoon and welcome everyone to our fourth lecture in the Law, Politics, and Media series this semester. I'm Keith Bybee and I direct the Institute for the Study of Judiciary, Politics, and the Media here at Syracuse University. And we co-sponsor this Law, Politics, and Media series every spring with the Tully Free Speech Center that's directed by that young man there, Dr. Feelgood, the man with the magic hands, Roy Gutterman. Today, we are fortunate enough to have Tom Bruce, who directs, was co-founder and is director of the Legal Information Institute at Cornell. Legal Information Institute is, it's a big deal. It gets over 120 million page views a year. The Legal Information Institute accounts for, I learned at lunch today, over 2/3 of the web traffic that Cornell University receives. The LLI alone accounts for that share of the web traffic. LLI itself, created in 1992, gave rise to LLIs, or LEAs as they are called, all around the globe. You can find them in other countries around the world. Tom Bruce himself has had a diverse and interesting career. After receiving his undergraduate and graduate degrees at Yale, he worked for a decade as a stage and production manager in theater. At the American Repertory Theater, at Houston Light Opera, did a number of industrial shows. At the same time, I think it was around this time or maybe later, he authored the first browser for Microsoft Windows, internet browser, Cello. So a guy of many talents. He has been with LLI since the beginning, and we couldn't be happier to have him addressing us this afternoon. Just a few quick remarks about how we'll proceed before I turn over the podium to Tom. He will speak for about 35, 40 minutes. Then we will have Q&A until 5 o'clock. And as is our typical practice, we will have a reception right here in the room. And I hope you can all stick around and join us for a continued conversation. Without further ado, please join me in welcoming Tom Bruce.
Thanks for that very generous introduction, Keith. I intend to run through a fairly wide range of stuff this afternoon pretty quickly, so if we could hold questions for the end, I like to be more interactive than that, but I'm on a bit of a fast train here. I'd actually like to start today with some hot numbers, a statistical tale about the election that has just occurred and its aftermath. As Keith has told you, I run a website along with a number of other people that publishes law on the internet, particularly federal statutes, federal regulations, and the Constitution, although we have many other things in our collections as well. Those are the big ones. And throughout the year, if you had been looking at our log files, you could have told that an election was underway. We got our first inkling of this around the time of the first GOP primary debate in August of 2015, when we clocked something like 500,000 hits on the Second and 14th Amendments during the middle 20 minutes of the GOP debate. It was clear that people were hearing discussions about gun control, looking at the Second Amendment, and looking at the 14th, because it was figuring very prominently in discussions of the ACA and of immigration. I think, in fact, there's a huge amount of public confusion about the 14th Amendment because, what has all this got to do with equal protection? But anyway, it was a very popular thing to look at. And as the election season wore on, and God knows it did wear on, we saw incredible amounts of traffic on different sections of Title 18, which are the federal criminal statutes in the U.S. Code, as many of you know. I'm going to try to make a little audience participation game out of this. I'm going to list off the three biggest traffic spikes that we saw and what they were. And you see if you can tell me which election season event prompted them. So here's the first one, 18 U.S.C. 879, threats against former presidents and certain other persons. Anybody know why we would suddenly see a lot of attention going to that? Dead silence. Okay. That all stemmed from Trump's suggestion that, quote unquote, Second Amendment people could do something about Mrs. Clinton, right? So that was seen as a threat against a member of a former president's family and a former Secretary of State. So lots of public attention went to that at the time. Let's try another one. This one's a real fat pitch. 18 U.S.C. 793, gathering, transmitting, or losing defense information.
This is during the election?
Yeah, during the election campaign. Yeah, Hillary Clinton's emails.
Yeah.
Finally, 18 U.S.C. 594, voter intimidation. Okay, that one's kind of a trick question, actually, because it was a steady drumbeat throughout the election cycle at elevated traffic levels, but it got particularly bad at the point where Trump was suggesting that his troops go monitor the polls in those neighborhoods. Right? That was when we saw a bunch of that stuff. So that was all kind of fun. And then we got to January 30th and 31st of this year, after the election, when the LII's website actually saw the highest traffic counts that we have seen since the Bush v. Gore decision in 2000. That was actually kind of a special event. We were the only people who had that decision online for about 14 hours, and we were at 5,000 hits per minute the entire time. Anyway, on the 30th and 31st, on the 30th we saw about 324,000 sessions. That would be on the order over 1 million page views. And on the 31st it was worse. It was 432,000 or so, which is around 125,000 to 250,000 more visitors than we get on a typical weekday. I mean, we were looking at this and saying, what is all this about? And as you might have guessed by now from the timing, that traffic was entirely to two sections of Title 18 having to do with the immigration ban, and one section of Title 50 that describes the eligibility requirements for membership in the National Security Council, aka the Steve Bannon statute. Now, all of those little stories about election traffic form a very appealing, almost romantic narrative that is particularly useful if your job is to give a talk that's part of a series on law, politics, and the media, right? I mean, here is evidence that people want to read the law for themselves, that they particularly want to do so during times of civic unrest or uncertainty, and it's true. It's important, and it's something that my colleagues at Cornell and I find very motivating, and as I say, it's a very romantic story in a way. But it is also only one story among three that I want to tell you today, which are a larger set of stories about open access to law, why it's important, and how open access to law actually works. And I think what you'll see is that, as is often the case in life, the less dramatic stories end up being far more important in the long run. Let me backtrack and say a few more things about the place where I work. As Keith mentioned, I direct something called the Legal Information Institute. We are a wholly owned subsidiary of the Cornell Law School. We've been around for 25 years. We were started in 1992. At that time, we were the first legal website and roughly the 30th website in the world. We put the first Supreme Court decisions on the web in 1992, 8 years before the court got a website. We wrote the first web browser for Windows in 1993 and put the first edition of the United States Code on the web in 94, first XML edition in 2001, and we added the CFR after many years of trepidation at taking on this task. We put the Code of Federal Regulations online in 2010. We were not the first to do that, but we still think we have the best version out there. Every year, we serve out information to about 32 million unique individuals from 246 countries and territories. As Keith mentioned, we account for about 2/3 of Cornell's web traffic. There are 9 of us. A slight majority are software engineers, but there are also editorial people, and we make use of the talents of about 40 law students, 30 of whom work on a vague equivalent of a journal, about 10 of whom are involved with other editorial work. And we get a lot of project support from roughly 20 Masters of Engineering students per year from the Computing and Information Science programs at Cornell, which are, for our purposes, a farm team for Facebook, Amazon, and Google. We get very good engineers from these guys, and they do great work for us. We are supported, at least in part, by donations from individuals. Our donors include a former Solicitor General of the U.S., 2 former holders of the general counsel position at Homeland Security, and the CEO of Lambda Legal, which tells you, we sort of span the culture and the politics. We have sort of neutrality that comes from taking in everybody equally. So I already told you one story about open access to law and its importance, and that is the informed citizen or civic impulse story that I just told you about the election. So you have an important civic event like an election taking place. Candidates are making statements about what the law is or what it demands. Maybe they're criminalizing their opponent, or maybe they're debating some highfalutin aspect of policy, and suddenly people want to know what the law actually says. They want to read it for themselves. They want to try to understand it. Now I'd like to tell you another story that is equally important, and equally important to sort of get out of the way. And that's one that I imagine you've thought of for yourselves, which is this normative story whose title is basically "Ignorance of the Law is No Excuse." So if you think about how that relates to legal publishing, the idea is that if ignorance of the law is no excuse, then there's some obligation on the part of people who create the laws to make them known to those who are going to be governed by them. Now, that is an idea that has been around for a very, very long time. In English, it first surfaces in Cook's Institutes of the Laws of England, published in 1628, Cook's Commentaries on Littleton. But the actual idea had been around since Roman times. Politically, in Cook's day, it was pretty hot stuff, because if you'll recall from that legal history course that you slept through, that was a time when the work of the law courts and the legal system was largely conducted in a very strange language known as law French, which was a sort of bastardized French-Latin hybrid, not understood by anyone who was actually governed by those laws. So Cook was very much making a political point, which is that people actually need to be able to understand this stuff if they're being governed by it. You could argue that we have the same problem today without the law French, but nevertheless, that's where it came from. It's a very compelling and very important idea, particularly as law school people like to. You want to argue this from a sort of normative standpoint. But it gets even more interesting if you start to think a little bit about who exactly is ignorant and what they might be ignorant about, particularly as you think of that in a more modern context like civil actions or administrative law. And you gradually sort of come to this realization that the practical details and the problems are far more interesting and have a lot more to tell us about what's really going on than we could ever get from the normative approach. I actually tried this in a seminar once. I had 15 law students sitting there, and I said, so, who do you think is ignorant and what do you think they're ignorant about? And I got 14 answers that were almost all the same. They were all a story about somebody representing themselves in a dispute. And you could tell that the students were working very hard not to make this overly melodramatic, but they're all thinking, it's Gregory Peck defending himself on a murder charge, right? You could see that was how they were thinking. And then the 15th guy stuck his hand in the air and he said, no. That's far too melodramatic. It's some person who's got a problem with a regulation. And he turned out to be right. He was a German LLM student, actually, which sort of speaks for itself. But it really is. It is a guy with a problem with a regulation. To sort of pile a dumb example on top of that, there are somewhere around 85,000 dry cleaning businesses in the United States. Huge proportion of those are family-owned. They're genuinely small businesses, not small businesses because the government defines them, but really small family-owned businesses. There are 128 sections of the Code of Federal Regulations that deal with the handling and disposal of dry cleaning chemicals. And ignorance of the law is no excuse. So, do the math and start thinking about what people might be ignorant about, because there's really quite a lot to be ignorant about. So all of that to say that I would really like to take a slightly more down-to-earth approach today and start really looking at the nuts and bolts of how this stuff works a little bit in the time we have remaining to us, with three ideas that I think taken together form a kind of practical perspective on the problem. First proposition is that it is simply too damn hard for people to find out what the government thinks that they are supposed to do. Surprisingly, a lot of the people who find it too damn hard to find out what the government expects them to do are actually in the government. One of the recurring lessons in the world of LIIs is that government's access to its own work product tends to be terrible. And every operation I know of the 25 LIIs that have been established around the world has benefited in an early stage from some ally within government who is really some guy who can't get something he needs for his job. It's a problem. It's a problem in the U.S. It's a problem everywhere. Uh, Second proposition, it is not hopeless or unreasonable to expect that people will be able to understand the law if they can actually find it. That's a slightly more controversial proposition. There are certainly significant impediments to that. I think, as we'll see in a few minutes, they may not be what you think. And very often people are not finding the stuff for themselves. They're intermediaries who are either using it to advise someone else or to present to someone else. So that's a slightly different problem. But in general, we find that people are a lot better than you might think they are at understanding what they find when they find it for the purposes that they need to put it to. And that's an important qualifier that we'll come back to. Third, there are numerous practical benefits to having law be both available and accessible to everyone. And again, they're not quite what you think. By available, I mean out there where someone can actually read the law for free. And by accessible, I mean understandable. So once you sort of take on the perspective formed by those three propositions, you start asking questions like, who are these people and what do they want? Which is very different from trying to tell them what they should want. And we're going to spend the rest of the time today talking about who they are, what they want, and what is actually in their way. I'm learning to manipulate my software here. So let's talk a little bit about who's in that audience, and actually start by asking, well, okay, how do we actually know anything about them? Most of our evidence for everything I'm about to say comes from log files and other standard web analytics, ours, those of some of our friends in the business. These, for those of you who are not webheads, are records of what people actually look at on the website, what links they followed to get there, what order they looked at them in, when they looked. And we can often, as my election examples suggest, tie those to events in ways that strongly suggest motivation. So to take a particularly depressing example, in the wake of the Newtown school shootings, we saw traffic to the Second Amendment go up on the order of 3,000%. There are also less obvious examples. I was parading one around at lunch today. We looked at one point at whether there had been any discernible effects from 9/11. We expected to find some upsurge of interest in the anti-terror statutes that existed at the time. There was a little bit of that. But the most interesting thing actually happened about 2 weeks later when there was a sudden upsurge of interest in flag etiquette. How you handle and display the flag, when you should fly it at half-mast, et cetera, which is a very, very cultural thing that we certainly did not expect. There's a lot of interesting work, by the way, to be done around looking at that sort of stuff, and we've not done nearly enough of it at this point. Aside from the log files, and believe me, we have plenty of those. We generate about 2 gigabytes of log file data a day. We have the advantage of some surveys. We occasionally ask people to tell us something about themselves. Most recently, in a sort of comprehensive way, we did a formal study on readability of legislation with 2 researchers from Australian National University, where we got 45,000 responses in which people actually gave us quite detailed information about their professional situation and what they knew, what they didn't know, what they were looking for, that kind of stuff, which was very helpful. Plus, we throw out a variety of surveys and questionnaires and other kinds of interactions with both the people who donate money to us and people who come to us with either looking for or giving advice. Hey, that statute's out of date and that kind of stuff. We get a lot of very good anecdotal information from them that helps guide us in looking at the statistical stuff. So putting all that together, what do we know about this audience generally? Well, a first point is that it's not new. This audience for open access to law is an audience that has always existed. It predates the net. It found its material in different ways in the past. Like a lot of audiences of that kind, it always existed. The internet kind of concentrated it and pinned it down where we could see it. But for a long, long time, people have been getting that information through print, and they've been finding it in public libraries and government libraries and those sorts of places. There were also a lot less obvious but pervasive information sources, legal self-help guides. I mean, think about the sheer number of books there are out there on tax preparation, just for one, or the series of books that was put out by Nolo Press that were basically man-in-the-street stuff that helped you if you had a neighbor with a barking dog, and that sort of stuff. There's been tons of that over the years. Citizens Advice Bureaus, not a thing in the US, but very much so in Canada and the United Kingdom, places where people can go to get essentially low-level legal advice on common matters. And most of all, and still with us, what I refer to generically as you and the law articles, which vary, from everything, across everything from the stuff you find in the local newspaper that talks about, problems with your neighbor trespassing or building a fence or whatever, up to things that you find in trade publications for financial advisors that have quite complicated and sophisticated discussions of securities regulation, real estate law, all that sort of stuff. Practically every profession has a trade magazine like that, and at one time, they all had those sorts of columns in them. These days, you find all that stuff in blogs, and there's a lot of it out there. It is a time-honored practice for lawyers to troll for business by writing those things, and they write quite a lot of them. Second thing about this audience, it's large. As I said last year at the LII, 32 million of these users, 124 million page views, and we are only one source of that information. So if you take our audience together with GPO and various other people who are publishing essentially the same stuff in different forms, it's a good, it's a good sized number of people. It's growing out of proportion to the way the internet use is growing. We had 12 million users 5 years ago. Now we have 32 million. That strongly leads growth on the internet. So, now that we know a little bit about the broad contours of these folks, what about them in particular? We routinely talk at the LII about 3 divisions in the audience, 2 of which I think you would expect, 1 of which I think you might not. The obvious one, of course, is lawyers. Lawyers do tend to use legal information, lawyers and law people, judges, public officials. Interestingly enough, it's not concentrated in any particular area of practice, although in our particular case, we get a lot of tax practitioners because, frankly, our version of the tax code is far more usable than anybody else's. So we get a lot of those guys, but really, you can't point at any one practice area as being disproportionately represented. It helps that we offer the federal rules, which brings in practically everybody. But really, it's cross-disciplinary. You do see some areas that are stressed a little bit because they are basically usually done as pro bono work. So veterans benefit stuff in particular, we get a lot of that because nobody has a research budget for it. But really, it's very broad-based. So law people. Second group are the people that lawyers would expect would use a site like ours, who are quote-unquote average citizens, whatever that means, who are having some kind of episodic traumatic encounter with the legal system. They're going bankrupt, they're getting divorced, their kid got busted for drugs, whatever. It's some personal encounter with the legal system, infrequent, one-time, man-in-the-street sort of stuff. Most people, I think, would stop there, but actually there's a third group, and it is possibly the most important one. About 25% of our users are people that I would call non-lawyer professionals, by which I mean people who are making continuous professional use of law, but are not lawyers themselves. So, for example, hospital administrators who spend their lives looking at public benefits law, journalists, police officers, anybody in regulated business, particularly non-lawyers doing regulatory compliance. And when you say anyone in regulated business, you mean basically anybody in business. If we look through our donors, we find people who help with tax assistance programs for the elderly. We find a procurement manager for a food bank in Ann Arbor. We find a woman who does construction quality control work for contractors who have federal contracts. We find music industry executives, accountants, law enforcement trainers. Now, this is a very, very, very diverse and important group, not just in numbers, but in terms of how we think about the problem of people who are trying to find this stuff and what their level of expertise is, and so forth and so on. Now, let me draw sort of an underscore under the man who is not there. Notice who's not in that list. Who is not in that list is pro se litigants. Right, the one group that lawyers would most think would use a service like ours are just not there in significant numbers at all. These are not people who are representing themselves in disputes. They're doing something very, very different from that I will talk about in a moment. And it becomes a little more obvious what it is when we start talking a little bit about what they're looking for and why. Having dry mouth syndrome here. It turns out to be very, very helpful when you think about open access to legal information to think about people who are not actually involved in a dispute. So just to list some ways that open access to law works in contexts other than disputes. For one thing, legal publishing is a way that official bodies can showcase what they do. It is not an accident that the legislatures were much quicker to get their information online in the mid-90s than the federal agencies actually were. Representative bodies tend to want people to be able to see what it is that they're doing, if they're actually doing anything. So they have a lot of interest in seeing to it that that stuff is out there. And it's been kind of surprising just over the last 3 years how bipartisan the push for congressional transparency on legislative branch information has actually been. I was quite surprised that Boehner and Cantor were taking the lead on this a few years back. You don't normally associate that kind of transparency with that kind of politics, but that's what they were doing. Secondly, open access to law provides a way of advertising economic opportunity. Imagine that you have two states that are competing for industry, who are competing for economic investment, or a small country in Africa or whatever that's trying to attract direct foreign investment. It's very, very helpful if you are in that situation to make it clear to people, first of all, that you have rules, second of all, what they are, and third of all, that you have the capacity to enforce them. So if you look, a glaring example of this happens with the jurisdictions, the international jurisdictions in which a lot of offshoring takes place. So think about Jersey, the Seychelles, the Caymans. They've been very quick to get their finance laws out there because effectively it says, hey, come on down. It's also true of Rwanda, by the way. They've done a fantastic job of putting their economic development stuff up. It's typically what you find. The trade law goes up first because they're looking for foreign investment. That's kind of a special case of a more general proposition, which is that open access to law is a tremendous indicator of legal stability, and it's a kind of risk management tool. It's a planning tool for business. People look at this. There are people who look at pending tax legislation the same way farmers look at the weather report, and for more or less the same reason. It tells them what their business conditions are going to be. Couple more things. Open access to legal information is often an antidote to corruption, because very often corruption is the result of a kind of information asymmetry between what people know and what government officials know. So it's kind of an anti-corruption technique. And it's also the basis for communities of legal practice, not as we think of law practice in the US, but more kind of regional approaches to jurisprudence and regulation. So one of the things that we've seen in Africa is more and more of the countries there have started putting their stuff online as a kind of everybody looking at everybody else approach to things like environmental regulation. They've kind of hit on a regional approach there, and that happens more and more as more of this stuff goes up on the net. But out of that list I just rattled off, I think the top level concern, the biggest one, is just management of risk and general predictability. People walk up to open legal information systems asking, what is going to happen to me if I do this? How is the law going to affect my plans, either for myself or for my business? And an interesting thing about that audience, or at least strange to people in law schools, I think, is that they don't really care about case law in quite the same way that lawyers do. Because again, they're not researching something for a dispute where they're looking around for precedent. They're trying to do risk management. So their main concern with case law is as a form of interpretive guidance. They want to know what the case law says about how to interpret the reg or how to interpret the statute, not sort of what it says in and of itself, which is a very interesting sort of, it's subtle, but it's pervasive in how that affects the way that they actually look stuff up and the practicalities of delivering it to them, because it's almost end around from what we expect. Let's talk for a minute about what kind of barriers they face. We talk about open access and free access kind of interchangeably because traditionally the barriers for people being able to get their hands on this stuff were economic. Commercial legal services in the United States are expensive. Law books were expensive, lumpy, and unevenly distributed. That's an issue that is disappearing as more and more government bodies are publishing the stuff directly, although it is still an issue with things like technical standards that are incorporated into regulations like the National Electrical Code or some of the regs regarding nuclear safety, all of which are published by private standard bodies that charge for access to the material. There's actually quite a lively debate going on around that incorporation by reference issue in administrative law circles these days. But I really wanted to talk about three others that I think are important. The first and most obvious is readability barriers. The second are hostile retrieval systems, and the third are kind of vaguely defined as barriers in the structure of the corpus that often stem from government structure or procedural considerations, and I'll give you a very lively example of that in a moment. Let's talk about readability barriers first. These have kind of been talked to death, and a lot of what's been talked about in connection with them is sort of beside the point. The trick is to focus this discussion on real notions of readability, not what we've talked about in the past, which has tended to be about things like fine print, right? So if you look at most of the plain English initiatives out there that mandate government to do certain things in publishing law to make them more readable by the public, it turns out really to be about typography. It's really about, the fine print at the bottom of the contract. An awful lot of that stuff is. It's also not about grade levels. It turns out that grade level readability measures are really very, very useless for predicting public understanding of legislative text. They're great if you want to organize a stack of books into a sequence to be read by elementary school children, but they're not so fantastic at predicting what the public is going to be able to understand if they look at legal language. All that to say that genuine attempts to find a balance between simplicity of language on the one hand and precision of legal meaning on the other are fairly rare, but you actually do find them. There's quite a good effort underway in the United Kingdom right now. It's called the Good Law Initiative. It's being run by the Office of Parliamentary Counsel in an effort to improve their draftsmanship in such a way that the public can actually read it. Another example from the US that was actually quite successful was California's revision of its jury instructions. They actually called in a bunch of legal linguists to take a look at the stuff to their great benefit. They simplified them. The effects have actually been fairly dramatic. Second big barrier, retrieval systems that are hostile to outsiders. That's my illustration of legal information retrieval in a nutshell. All information retrieval systems are basically slot machines. They allow people to exchange something that they know for something that they don't. And when the system is incapable of taking any of the tokens that the user actually has, it tends to fail. So people who design legal information retrieval systems or any information retrieval systems have to be pretty smart, not only about what the user is seeking, but what they're bringing to the table in terms of what they already know. And unfortunately, legal information systems are kind of notorious for being insensitive to that. My favorite example is an old one that no longer exists. When the Eighth Circuit Court first put up a database of their opinions for public accessibility, there was only one way to search it, by docket number. Now, think about who actually has a docket number, right? You would either have to be a party to the dispute or a clerk in the court to have that system be of any use to you whatsoever. And of course, 3 years later they changed it, but the fact that they thought that it was a useful idea at all says something about kind of insider hubris. And in fact, there are any number of systems out there that really aren't that much better. So for many years, regulations.gov, which is the place to go for federal regulatory dockets, was basically unusable if you did not understand agency structure well enough to know who was likely to be regulating what. Because at the top level of your search, you were required to tell it what agency you wanted to search in. And even if you did know what you were doing, there were certain cases that didn't support, use cases that didn't support very well. Like, for example, if you wanted to do research on a policy issue that was cutting across multiple agencies. Poster child for that is food safety, which touches somewhere between 15 and 17 separate federal agencies, if you really want to know what's going on there. And then, of course, there are all the dumb examples that we all know from the press, like the the fact that salmon is regulated by two separate agencies depending on whether they're in fresh water or salt water. Try to structure that into a search that's useful. These are all failures on the part of the information provider to realize who's asking what they already know. And of course, they're all over the place, and the devil is in the details. Finally, and this is my last barrier, and I'm running out of time, as I can see. Sometimes the problems of understanding how to find and understand the law are as much about how things are arranged as they are about what's said. There's a problem of looking in the wrong pigeonhole. Let me give you a really good, egregious example. I checked, I think you can probably read this in the back of the room, but in case you can't, this is good current law. This is 4 U.S.C. 1, which describes the flag and the stars and stripes on it. And it says, the flag of the United States shall be 13 horizontal stripes, alternate red and white, and the union of the flag shall be 48 stars, white in a blue field. Again, this is good current law, and it gets us about 3 emails a month saying, what the hell is the matter with you people that you can't keep your stuff updated? Hawaii's been a state for 60 years. What is the matter with you? Well, we actually got kind of interested in this question. So we started looking around a little bit. And the first thing we found is that if you actually look at 4 U.S.C. 2, that is the section that specifies the algorithm. That is the section that says there will be 1 new star per state. Now, if you had happened to Google this and you were a member of the lay public, you wouldn't necessarily think, oh, maybe I should look at the next section. And something else that you certainly wouldn't think of, unless you had been paying really close attention in that legal research class that you all slept through, is to take a look at the actual notes in that section, which you see here. Now, this is a little bit of a mystery, and you have to read it pretty closely, but if you look down here at the very bottom, you see Executive Order number 10834, proportion to the size of flags and position of stars, that mentions that the state of Hawaii has been admitted to the Union and goes on to add a star and so forth and so on. And because it's an executive order, it is not actually part of the statute. It only appears in the notes. And unless you know to look in the notes, you will not find it. Now, you may notice that there's a bit of an elephant in the room here called Alaska. What the hell happened to Alaska? And if you look up above here at Executive Order number 10798, you see that it was revoked. It had something to do with flags. It was revoked by Section 33 of 10834, the one we were just looking at, by which we can infer that the Hawaiian executive order bumped the Alaska one into this kind of anonymity here, from which we can now not find anything. Now, notice something about this. There are no hard law words here. Right? There is no term here that a layperson cannot understand. There is no promissory estoppel here. It is simply an artifact of the way that the stuff is organized, which in turn is an artifact of some notion of separation of powers and how stuff gets published and so forth and so on. So, the barriers to public understanding are not necessarily about the fact that they can't understand the hard words. It's often about the fact that the stuff is published in a kind of irrational manner. And I'll stop preaching there and just go on to spend the last couple minutes saying a little bit about the future represented here by a flying car. To do a little prognostication, just over some of the issues we've talked about in the last 40 minutes or so, I think the availability problem and just the problem of getting law where people can find it, it's largely solved in the United States, not completely, but more and more public bodies are putting their own stuff out there. It's getting easier and easier to find. Technology is there to do it. It is far from solved elsewhere, notably in the Middle East and in the Stands and in parts of Asia. And there are some surprising pockets of resistance even within the United States. If I had more time, I'd tell you a story about the New York Court of Claims, but it takes a long time, and it's an old story. There are scads of problems with accessibility of the sort that we've just been looking at, some of which, like readability, are inherent in the material itself. We're seeing some progress on that, people doing clearer legislative drafting, those 2 initiatives I mentioned. some of which are actually being surfaced by increased public interest. Nobody cared about incorporation by reference until they could look at the rest of the regs online, and then they said, oh, wait a minute, this is a problem. And we keep, uncovering nested little, people keep turning over rocks and stuff keeps running out. And that, that's a long slog, but it'll be solved. More of the problems and the problems that interest us really can be seen as data integration problems, really technical problems that are more problems in a kind of library science-y way than they are in a computer science-y way. So, I mean, this will all sound very geeky, I'm sure, but just the fact that there is no uniform system of identifiers for federal regulatory actions that actually works. For those of you who know this term, we can talk about why RIN numbers don't actually work later, but they don't. Agency write-ups of violations of regulations often do not contain a CFR citation. So you really have no idea specifically what reg has been violated. Dunn's numbers, the Dun and Bradstreet business identifiers, are pervasive throughout all sorts of stuff in the regs, and they are proprietary and they are expensive to use, and so forth and so on. Our focus has always been at the LII. We have no aspiration to be a free Westlaw. That's not really a possibility in the United States. What we do like to do is build interesting stuff that shows the way to doing a better job across the board. You can think of us as a kind of R&D center. We don't want to be a de facto national system like our Canadian or Australian counterparts, but we do think that we have an ongoing role as a kind of center for large-scale proofs of concept, and everything we're working on right now is really focused on those kinds of integration questions. How do we tie these collections more tightly together? How do we make it possible for people to follow their nose from one thing to a related thing to the next thing? And I guess I will stop there and take questions.
Thank you.
Sure.
So I was wondering about this solution to these problems of classification or pigeonhole problems. To look at the components of your audience that you have. The lawyers probably not less likely to have that problem. Maybe, I guess they sort of know where to look. It's just a matter of navigating the site, right? But I wonder if the solution to that problem is different for the average citizen who's having the episodic traumatic encounter with the legal system, to use your formulation, and the non-lawyer professional. I mean, it seems like the non-lawyer professional really wants to just zero in on the specific reg, right? Whereas the average citizen with this episodic traumatic encounter may want both forest entries, right? May want kind of like an account of what's going on, what's the process, and what's the actual rules, and so do you have is there one uniform way of solving the problem for these?
No, I don't think so. I think it's as diverse as you're suggesting it is, and we've seen a couple of good cracks at that. Something I use to bedevil my colleagues is the fact that my favorite legal reference book is something called the Reader's Digest Legal Problem Solver, which in its own way is a work of genius, because what it does, it lays everything out as a dictionary. So you have in this thing hard law words. You have promissory estoppel or what have you. But you also have words like neighbor. And they're words that you would use to complete the sentence, I have a problem with my neighbor, employer, et cetera, et cetera, et cetera. And when you look in those neighbor and employer places, you find that it leads you into things like the barking dog that turns out to be nuisance. Right. In fact, one of the things that one of the phrases we often kick around in my shop is, how do we get people from barking dog to nuisance? How do you get them from a fact pattern to what the underlying legal concept is in a way that allows them to proceed either into the case law or into other materials in a useful way? Similarly, you might guess, I suspect any good law librarian could probably tell you what the 100 most important interventions are in a legal research problem, because they get them at the reference desk and they look at people and they say, well, is this a state, do you know if this is a state question or a federal question? Right, and my guess is I once had this fantasy of inventing the legal research equivalent of what is colloquially referred to in my business as that fucking paperclip, which is the little thing that sits down in the corner and says, I'm here to help you, and would know when to intervene on those kinds of legal reference questions. And really, I think the number of interventions is quite small. Point is, it's all very custom designed. and expensive to do. Some federal agencies do a nice job with this, by the way. Look at some of what Department of Labor has done for man-in-the-street stuff. Other parts of it are more sort of follow-your-nose exploratory approaches that are better. Sometimes I think we would do well by putting some object up there and saying, here's all the law that relates to. Pseudoephedrine was the example I was using at lunch because it's very diverse. Different weapons for different targets, I think, is the answer there. Somebody else? Yeah. Uh-huh. Right. It's a good question. We had all of our stuff reviewed probably, I want to say 6, 7 years ago, because at the time we actually had a blind law student working with us who reviewed all of our stuff for 508 compliance and for usability by the blind. And we have not done that on a routine basis just because we haven't had the people available to us to do it. It's certainly something that I know government tries to do. How successful it ultimately ends up being for the affected populations, I really don't know. I really don't know. Yeah. You think about something like a provision in the tax code that's got all kinds of tabular information. I mean, people have been doing very interesting things with text-to-speech stuff for years where they'll read through tables and it will actually pan across in stereo as the thing is going across the table, so you have some sense of how the movement is occurring. But I really don't know of any large-scale effort to do that. I know that there are government standards for it. We try to follow them. Yes? Your comments were basically about the federal system? Yeah, because that's mostly what we do. States are worse, actually. That's what I was about to ask. Kind of depends on where you are. I mean, let's start with Pennsylvania. They've never codified their statutes. That would be a problem whether there were computers or not. States do a better and worse job. There have been some really stunningly good examples out there. California was one. Oklahoma, surprisingly, is one, particularly with judicial opinions. My colleague Peter Martin, I think, is on a first-name basis with every reporter of decisions out there in the States, and he's got his whole sort of ranking system for them. But there have been some notable successes, but there are also some notable failures. New York is not great, frankly. Oh man, that's a morass. That's really a morass. We actually did an experiment once where we were trying to find out how hard it was to get a copy of the dog licensing statutes in various municipalities around New York State. It was just ridiculous. We did it as a kind of joke, but the further you go down in the sort of food chain of the courts, the less incentive there was traditionally for the commercial publishers to involve themselves. And for all that I might make snarky remarks about Westlaw and Lexis, they did have a generally improving effect on the way that public records were kept in those courts and the way this stuff got published. And the places where they did not go, not much has happened, which is too bad. You're right. The municipalities and counties are they're a nightmare. Yes. Mm-hmm. Mm-hmm. Is that one area where you see a lot of people using it? I would think that'd be a pretty good resource for a reporter or something like that. Yeah, we do. We get a lot of traffic that's sent to us by newspapers. We get a lot of citation of some of our secondary materials as well. So we've had stuff. We've had stuff in the last year or so in the WAPO, the Chicago Trib, Times, et cetera, and we're linked to by those guys all the time. We have a pretty cordial working relationship with ProPublica, only because we've worked with some of their reporters on other kinds of projects. So, yeah, there's a lot of back and forth there. I was thinking, I had a little tidbit to throw your way on the media front. Actually, I don't know what this anecdote is worth, but I'll tell it. It used to be the case that we would get tons of email every time a cert denial came out of the Supreme Court, because the press would announce that as the Supreme Court has decided bibbity bobbity boo. And in fact, what the Supreme Court had decided was not to hear the case. And so what we would get as a consequence was all of this email saying, where's the decision? Right? Because it would be announced by the press that the Supreme Court had decided this. That has stopped. That has stopped. And I don't know if it's because the press is being a little, it's a little more knowledgeable about how they're reporting this stuff, or what.
When did it stop? In the last year?
Oh no, it's longer. It's longer. There's no question in my mind that the press in general over the last year has upped its game on this stuff. I'll be very curious to see how they do with the regulatory stuff, because they're weak on that right now. And frankly, it's hard to do. I mean, we've been thinking about what our response to some of the recent events would be. And, we are at some pains to maintain both political and intellectual objectivity for obvious reasons. But we do think that the regulatory system is poorly understood. There are lots of places in the holes and corners of the regulatory system where all kinds of mischief can take place, simply because the monitoring systems for regulatory change are not that good. Federal Register is a very blunt instrument in a lot of ways. And so we're looking at what can be done there.
Do you have, I mean, there have been other entities that have arisen during the time that you've been around. Think about SCOTUS blog. Like that. And does that affect your traffic? Or are these synergistic, or how do you all relate to each other? I mean, they're not an open access outfit. They're more of a kind of
No, we
24/7.
We have this kind of bizarre relationship with SCOTUS blog, actually, because for years we had this kind of detente. We have a student publication that actually does analyses of Supreme Court cases before they're argued. We've had that for many years. It has an email subscription list of around 16,000 people at this point, and it's in the magazine of the Federal Bar Association. So for years and years, we kind of owned the beginning of the process, and SCOTUS blog owned the end. And then in the wake of the healthcare decision, when they sort of called it right and nobody else did, they started moving toward the beginning of the process as well. And we thought, well, should we really be continuing this student publication, given that they're horning in on that territory? And just about that time, they ran out of money. So we actually have quite an interesting cooperative relationship with them at this point. We're referring to each other. They're pointing at our stuff, and we're pointing at theirs. So there's been a kind of trailer park marriage there. I think it's good.
Doesn't Bloomberg fund them now, or didn't they get Bloomberg funding?
That dried up.
That dried up.
Yeah, and in fact, Bloomberg's entire legal operation, I think, is adrift at this point, if not in active decline. Yes.
How fast do things get updated, statutes and regulations?
We update at the same speed that we can get the source material, which for the U.S. Code nowadays is within about 3 days of current legislation, and for CFR, maybe a little less, maybe a little sooner. So it's really pretty good. No. What they do, I'm going to do a little bit of a dance here. What Westlaw and Lexis traditionally did, let's go back a few years to the point where the Office of the Law Revision Council was only putting out updates to the U.S. Code once per year per title, which meant that at any given moment, their official version online could be as much as 18 months out of phase with current law, sometimes a little longer. What the commercial publishers did at that point, they tended to hire people who had actually worked for the Office of the Law Revision Council to come work for them and effectively pre-codify the stuff. So what they were putting up as being these utterly up-to-date versions were in fact being unofficially codified by their own staff. And you can get picky about the accuracy of that. It was actually pretty good because first of all, these guys really did know what they're doing, and second of all, there's no great mystery when a statute says blah, blah, blah is amended as follows, to stick the amendment in. That's not hard. But it was a little bit of a deception. And of course, they're still doing that. I have a feeling that as time goes on and as primary legal information becomes less of a profit center for them, as it clearly has over the last several years, you're going to see that wither away and everybody's going to kind of converge on the same lousy standards that we use.
Is that better, a lot better than it was 5 years ago?
Oh, God, yes. Oh, God, yes. You know, it's funny, there was a real change of heart at the OLRC. For a long time, I was at this meeting in Washington where the guy who was the new Law Revision Council's office, they're the guys who do the codification for the U.S. Code, got up and said, you know, you should know that we're making a real change in our operation. For many years, we have thought of ourselves as primarily having an archival function, and we are now thinking of ourselves as the first step in promulgation to the public. Which sounds like the sort of thing that, you know, only a law geek could appreciate, but it was a very, very significant statement. They very much see themselves as the first step in the publication process at this point. They're doing some very, very interesting stuff to try to get it as current as possible. There are always going to be limitations. Yeah.
I noticed on your website you accept sponsorships or advertising.
Yes, we do.
What are the considerations that you went through in deciding to accept them?
We needed the money. No. It was an intricate decision for us. We are a non-traditional activity for an American law school, extremely non-traditional and not always a comfortable institutional fit. And so there's sort of a history there, and I'll trace it for you. Back around, I want to say 2006, 2007, I and two of my lieutenants were sitting around and looking at the state of what was being done in legal informatics research in Europe in particular and saying, boy, you know, we know how to do all that stuff. We just don't have the money to do it. And, you know, at this point, we're turning into this kind of caretaker operation for this, you know, this library of public information. And we'd really like to get back to doing some active research, but we can't afford it. We need some money. And at that point, we started taking advertising on the site basically as a way of forming a war chest to do other things. I'm happy to say that 7 years later, we're starting to phase it out. It will be gone within 2 to 3 years in favor of a system of corporate sponsorship that we're introducing starting this spring. In fact, I was in the middle of a long email chain about that this afternoon. But at this point, we are roughly 3/4 self-supported, both through donations, through a business partnership that we have with a company that does a lawyer directory, for which we basically provide SEO. And the advertising budget, which is getting to be less and less of a thing for us, and is ultimately going to disappear altogether. But we were not going to, you know, funding for this kind of work, funding models for this are really, really odd, because I don't know if you've ever seen that famous Thomas Nast cartoon of the Tweed Ring. In which every politician is standing there pointing at the next guy in the circle. This is what funders are like when it comes to legal information. As well, you know, he ought to be doing it. Government thinks the foundations ought to be doing it. Foundations think the government's already doing it. Everybody wants the academics to do it for free, et cetera, et cetera, et cetera, et cetera. It's a tough area to find grants in, and we have basically no dependency on grants at all. We take them when we would be embarrassed by not applying, basically. But they're a huge pain in the neck. So we're happy to have developed these kinds of entrepreneurial funding sources, and it's actually done quite well for us. And we're now trying to sort of trim it back to the point where it's a little more seemly. We don't like the ads any better than you do, and actually, when we went into it, there were very, very careful policy considerations about where we would and would not take advertising. You'd have to look around, but for a long, long time, we have no advertising on the Constitution. We have no advertising on anything that has to do with the military, reproductive rights. There's a list of 10 or 12 of those items. So we really tried to stay away from the hot button stuff because, frankly, the last thing I need is an ad from the National Council of Catholic Bishops on the decision in Roe v. Wade. Right? My phone does not need that, right?
We are out of time, but before I invite people to thank you for speaking to us, I just want to mention that you do occasionally testify before Congress, and you did so just this year, wasn't it?
Yeah, yep.
On legal information. And so that's something we don't have time to discuss in the Q&A, but I wanted to put that out there so the conversation continues during the reception. But having said that, please join me in thanking.
Well, thank you. Thank you. It's been a blast.